Right, well, I think we might, it's probably time to kick things off. So good morning, everybody. Thank you very much for joining us and welcome to Wilberforce Chamber's Hot Topic webinar on the recent Supreme Court case of Alexander Devine Children's Cancer Trust and Housing Solutions Ltd. That's a case on the modification or discharge of restrictive covenants under Section 84 of the Law of Property Act 1925. Now, this is the very first case in which either the Supreme Court or the House of Lords has considered Section 84, and Martin and James acted for the appellant, although they didn't act before the Upper Tribunal Court of Appeal. And today, they're going to give us all their insiders' insights into the case. Now, Martin and James need no introduction, really, and I'm not going to be one of those people that says Martin and James need no introduction and then introduce them. If you don't know them already, you definitely should. But let me just say this, Martin, who is one of my absolute favourite property silks in Chambers, please don't tell the others I said that, is really the go-to silk on restrictive covenant matters, having appeared not just in this case, but also 3 recent leading Court of Appeal cases on the subject. James has seen Martin's 3 Court of Appeal cases and raised him 3 Supreme Court cases, having also appeared in the Cavendish penalties case and the Manchester Ship Canal case, which was a case about untreated sewerage being discharged into the Ship Canal. I had the pleasure of being involved in that as well at one stage, and adopting the language from the Public Health Act 1875. We often describe each other's practice as a result as excrementitious. Before we get going, I'd just like to invite you all to ask questions through the Q&A function throughout the webinar. It may be that we'll be able to pick up on some of them as we go through, but in any case, there'll be time towards the end. And like I say, please use the question and answer function rather than the chat function so I can make sure that I pick them up. Okay, so let's dive in. And James, perhaps you could start off by setting out the factual background to the case.
Sure. Thanks, Ben. The story began back in 2013 when a developer, Millgate, was planning a development near Maidenhead. And in order to satisfy the affordable housing requirements, it purchased a different site, a site called the Exchange House site. And it duly applied for and received planning permission to put up 23 affordable housing units on the Exchange House site. Now, the land around that site included land owned by a local landowner, a Mr. Barty Smith, and in particular it included land which in 2012 he'd gifted to a charity, the Alexander Devine Children's Cancer Trust, to build a hospice on for children with terminal cancer and their carers, and construction on that hospice started in September 2015. Now, for the purposes of the application to the Upper Tribunal, it was assumed that the Trust had the benefit of restrictive covenants over part, but crucially not all, of the Exchange House site. And those covenants prevented the building of any structure of the land, and they prevented the use of the land for anything other than parking. Now, I say it's crucial that the restrictive covenants did not cover all of the Exchange House site. And that's crucial for the following reason. The Upper Tribunal found that Millgate could have laid out the site differently, and it could have constructed all 23 affordable housing units on the unencumbered part of the land. And that's very important, and we'll come back to that in due course. But in any event, Millgate went ahead with its development in knowledge of the covenants, and without any negotiation with Mr. Barty Smith, or indeed the Trust, and the Trust was ignorant of the fact that it had the benefit of the covenants. Now, with development having started, enter Mr. Barty Smith, who one day took a trip in his light aeroplane and was surprised to see development happening on land he thought he had a covenant over. So there proceeded to be to and fro between solicitors, during which Millgate carried on with its development. And then once the development had completed, it issued an application in the Upper Tribunal, and it gave notice of that application both to the Trust and to Mr. Barty Smith. Now, the one final element of the facts I should mention is that very shortly before the application, Millgate had entered into a contract with our client in the Supreme Court, Housing Solutions, who's an affordable housing provider, to sell the affordable units to it, which duly happened shortly after permission to appeal was given was applied for to the Court of Appeal.
Okay, well, let's run through then, shall we, what was decided at each stage. So starting with the Upper Tribunal. Martin, what did the Upper Tribunal decide?
Okay, so at the Upper Tribunal, a number of grounds were put forward for modification, but in particular, Millgate relied on both limbs of ground AA, the most frequently relied on ground. So as far as the first limb of ground AA is concerned, what is often called the limited benefit test, Millgate argued that the user was a reasonable user because they got a planning permission. There was no real argument about that. And that the benefit to the trust was not of substantial value or advantage to it. And what the Upper Tribunal decided on that point was that Millgate were wrong. It rejected Millgate's case on the limited benefit limb, relying particularly on the fact that the development overlooked the trust's gardens, causing a loss of privacy, and that even though that could be mitigated by some planting, the cost of that planting alone, the fact that that was a significant cost, showed that there was a benefit of substantial advantage or value to the trust. So the tribunal then moved on to consider the public interest limb, that is, that impeding the use of the land for the intended user was contrary to the public interest. And as I suspect, as many of you will know, that's a limb that's often pleaded or relied on, but rarely successfully. And the reason for that is not least because an old case before the tribunal back in 1974, the Old Lands Tribunal, said that in order to succeed on the public interest limb, you had to show that the public interest was so immediate and important as to require an interference with private contractual rights. But the tribunal decided that that threshold in relation to the development of the 13 affordable houses was indeed met. They secondly decided that money would be an adequate compensation for allowing the covenant to be modified, and they fixed a figure of £150,000, principally to cover extensive hedging, which would help to screen the development from the gardens. So the next consideration, the final consideration the tribunal had to take into account was the exercising of its discretion. And in that regard, it took account of what it described as the egregious breach of covenant by a Millgate in knowingly building in breach. But nevertheless, it said that balancing all matters, modification should be granted as a matter of discretion. The fact that 13 families were waiting to be housed in social housing was said to outweigh all other factors, such that it would be an unconscionable waste not to modify. And so Millgate succeeded before the Upper Tribunal.
Right, okay, so we have jurisdiction on the public interest basis and also the Upper Tribunal exercising its discretion to modify. So James, what did the Court of Appeal then say about that?
Well, the Court of Appeal held that the Upper Tribunal was wrong at each stage. There were 4 grounds in front of the Court of Appeal, but there were 2 that really matter. And the first of those was at the first of those stages, Ben. It was at the jurisdiction stage, the stage of working out whether the impediment of the user is contrary to the public interest. And the Court of Appeal held that the Upper Tribunal at that stage should have taken into account the conduct of the applicant in building in knowing breach of the covenant. The way they put it was that the public interest ground had a procedural dimension, and that in general terms, it could not be made out by a developer who had failed to give proper respect to the importance of upholding property rights by seeking to negotiate the release of the covenant with the beneficiary before applying under Section 84. So that was a procedural requirement that it held in general terms developers had to go through. The second ground that really mattered related to the discretionary stage. It was argued by the trust in the Court of Appeal that the Upper Tribunal had failed properly to bring into account Millgate's conduct in deliberately breaching the covenant when exercising its discretion. They said that the Upper Tribunal should have automatically rejected the application for that reason. And the Court of Appeal accepted that. The words that the Court of Appeal used were that the Upper Tribunal failed to attach sufficient weight to the conduct of Millgate in exercising its discretion. Now, that form of words risks hiding the true import of what the Court of Appeal was saying. Because as the Supreme Court noted, the weight to attach to different factors in a discretionary judgment is primarily, or is a matter for the first instance tribunal. And the Court of Appeal must have realised that. So what the Court of Appeal were really saying was not that the Upper Tribunal had failed to attach sufficient weight, but that as a matter of principle, an applicant who has committed a deliberate breach of covenant should have their application refused, at least if that application is made under the public interest ground.
Now, it might flow from what you've just said, but perhaps you might just pinpoint then what is the, or was, the significance of what the Court of Appeal decided?
Well, I mean, I think the most important thing, before we even get to what they decided, was the trenchant way in which they stated their conclusions about an expert tribunal, a very experienced panel, including the deputy president, paying, it seemed, when you read the judgment, a little respect to its expert function and the difficult balancing act it faced in this particular case. But I mean, effectively, more importantly, what the Court of Appeal was saying, that in relation to the public interest limb, the Upper Tribunal was bound at the jurisdictional stage, in other words, before you got on to consider factors of discretion, to take account of conduct such that the threshold couldn't be met. In other words, effectively, because it was not in the public interest for covenants to be knowingly breached, the jurisdictional threshold could never be met, which effectively had the result of closing off the public interest limb in future cases to a developer, unless, in effect, the developer has engaged with the beneficiaries of the covenant beforehand and or brought its application for modification before beginning to build. Unless you did so, you were out of court. And indeed, as James points out, the Court of Appeal effectively went further and laid down a principle that developers knowingly breaching covenants should, in any event, automatically be refused modification on discretionary grounds in any event. And although this case was a public interest limb case, one can certainly read the Court of Appeal's comments as applying equally to the limited benefit limb of ground AA. Certainly, it was an alarming decision so far as developers were concerned.
Right, okay, pretty stark, pretty wide-ranging. Yeah, I can see that. So what did the Supreme Court do about it?
Well, the Supreme Court politely held that everything the Court of Appeal had said was wrong. Taking first the jurisdictional stage, the Supreme Court disavowed the notion of a procedural requirement at that stage. They held that the conduct of the applicant is irrelevant in determining whether or not the jurisdictional ground is made out. They said that the jurisdictional question is a narrow one. It's whether the impediment of the identified reasonable user by continuation of the covenant in question is contrary to the public interest. So it focuses on the use of land, not on any broader question as to whether or not it is contrary to the public interest to vary the covenant after conduct of the developer that the court might not like. Now, in this case, that made the question easy to answer. Clearly, the Upper Tribunal was entitled to hold that it was contrary to the public interest for 13 constructed affordable housing units not to be used. Now, moving to the discretionary stage, again, the Supreme Court disavowed the notion that there is a principle that a developer who has constructed their development in knowing breach of covenant should automatically have the application refused. But the way in which they did that introduces potential uncertainty for the future, and no doubt we'll come on to discuss this a bit more. Because Lord Burrows, who gave the only judgment, said that he was sorely tempted to agree that there was such a principle. Now, he resisted that temptation, but he thought the reason for doing that was that he thought that such a principle, and these are his words, without discretionary qualifications to cater for exceptions, would be too rigid and inappropriate. So he thought that there should be no such principle, and he refused to accept that the Upper Tribunal had made an error of law in failing to apply the broader principle wrongly identified by the Court of Appeal.
So it sounds to me like that was a triumph on all grounds, or is that just flattery on my part?
Well, flattery gratefully received, Ben. So you're asking us what the result in the Supreme Court was, I infer. Well, let's just go reel back on what the Supreme Court did, as James has outlined. So what they did was, in effect, to reset the clock on our understanding of the public interest limb. They did four things, really. They confirmed, contrary to what the Court of Appeal had said, that the traditional view that the public interest limb starts with a narrow consideration of whether, in impeding the identified reasonable user, the covenant operates contrary to the public interest. So they confirmed that traditional view of the jurisdictional threshold for the public interest limb. So in other words, the Upper Tribunal doesn't ask the wider question, is modifying the covenant in the public interest, bearing in mind the developer's behavior? All good news. Secondly, the Supreme Court confirmed that the right place, therefore, to consider matters of behavior were at the discretion stage, not at the jurisdiction stage, which was precisely what the Upper Tribunal had correctly done. Thirdly, the Supreme Court confirmed that the question at the jurisdiction stage was not, as the Court of Appeal had at least implied, whether maintaining the restrictive covenant is contrary to the public interest, and that the Upper Tribunal had not made an error in its interpretation of the jurisdictional threshold and what was relevant and what was not. And then fourthly, it rejected the Court of Appeal's notion that the Upper Tribunal's approach in relation to discretion, that as a matter of principle, the Upper Tribunal should refuse applications in all cases where a cynical breach occurred. That notion of, that the Court of Appeal had put forward was wrong. So, in answer to your question, no, the Court of Appeal's decision was upheld. So the way the Supreme Court got there, frustratingly for us as appellants, was this: that having found that the Court of Appeal had therefore wrongly, effectively overturned the Upper Tribunal's decision, both in terms of jurisdiction and discretion, the Supreme Court went on to identify two errors that the Upper Tribunal had made in the exercise of its discretion. In other words, they were, that is, the Supreme Court, entitled to re-exercise the discretion. And those were two factors which hitherto, both before the Upper Tribunal and before the Court of Appeal, had played no part in the argument that the respondent had advanced in relation to the discretion. And those two factors were as follows. Firstly, they said that the Upper Tribunal had failed to take into account that the development could have been built without breaching the covenant. As James mentioned, it was common ground before the Upper Tribunal that the whole of the development could have been built on the unburdened land, and the burdened land left as a car park, which was what the covenant effectively restricted the use of the land to. And what the Supreme Court said was that the Upper Tribunal must deter cynical breaches, but particularly where the breach itself has not in fact been necessary at all, and the covenant could have been respected. So that was the first error that the Supreme Court identified. The second error, and perhaps in a sense the more fundamental error that was identified, was that the Upper Tribunal didn't take account of the fact that the breach itself had created the public interest. In other words, the breach created by Millgate, in other words, the building of the 13 affordable houses, was in effect being relied upon by Millgate as the very state of affairs that gave rise to the compelling public interest. And on that basis, the Upper Tribunal felt, the Supreme Court felt that it could re-exercise its discretion, and it re-exercised its discretion taking account of those two factors against Millgate and in favour, therefore, of the respondents, therefore upholding the Court of Appeal's decision. And I should just point out, if we haven't already made clear, that we acted, James and I, for Housing Solutions, who were the social housing provider. So they were not, in fact, the party that had been responsible for the breach, but had been given indemnities from the developer in respect of the proceedings.
So perhaps it's little solace for your client, but at least you can say that you put the law right. Right. Well, thank you very much for that description. What we can do now is broadly move on to a question and answer phase. What I might just do is remind everybody that please do ask questions using the question and answer function, and we'll try and get through as many of those as possible. I've already had something in, but while we wait for those in, perhaps I can just ask, what would you say this case means then for public interest cases going forward?
Well, for my part, and I think I've seen the question come up on screen, and I'll try and answer that as I speak. I think, although, as you say, it's scant comfort for our client, in broad terms, the decision is good news for developers and for their insurers, but subject to two major caveats. And the reason it's good news is as follows, because the rejection of the procedural dimension of the jurisdiction test means that developers don't have to go about tipping off potential beneficiaries of their ransom position out of fear that if they don't do that, they won't be allowed in due course to rely on the public interest ground. So that has to be good news. And perhaps just at this stage, I can address the question, which asks, first of all, was there an indemnity insurance policy in relation to the covenants affecting the exchange house site? To which the answer is yes. And then asks, what are the consequences of this decision for parties who hold restrictive covenant indemnity policies and are told explicitly not to contact the parties with the benefit of the covenants? Well, hopefully what I've just said addresses that. There is no longer a procedural requirement on you to do that if you want to rely on the public interest ground in due course. So that's good news. But the two caveats are as follows. First, as Martin has introduced, it appears pretty clear that a developer will not be allowed to rely on a public interest ground or a public interest that would not have existed if the application had been made before the construction of the development. So they can't say, well, those houses are here, so don't knock them down. If they couldn't have said before development, the public interest requires these houses to be built. And that perhaps in many ways is not too surprising a position, because it's consistent with the approach of the Upper Tribunal in pre-construction public interest cases. Because in those cases, an application will ordinarily be refused if the applicant has failed to show that the relevant public interest cannot be satisfied in a way which doesn't involve a breach of covenant. The second caveat arises out of the way in which Lord Burroughs rejected the principle laid down by the Court of Appeal that if you act in knowing breach, you shouldn't have your application allowed. And as I said, Lord Burroughs's problem with that principle was not the sentiment in itself, but the fact that you need discretionary qualifications to cater for exceptions. And precisely what counts as an exception is nowhere explained, and so no doubt is fertile territory for litigation going forward.
Right, okay. Well, let me ask you this then. In light of the decision, what would you now advise developers considering ground AA applications more generally to do?
Well, I mean, I think first of all, if you're relying on the public interest, Lynn, if you've got an arguable case, the safest, although perhaps often unrealistic course, must be to seek to engage with known beneficiaries in open correspondence, being aware, obviously, as a developer, that at all times it's possible there will be close scrutiny of your behaviour at the Upper Tribunal hearing, should it be necessary. I mean, I think the other thing is, the other sort of practical point is that if there's a challenge by beneficiaries or potential beneficiaries, and this applies whether or not it's public interest or not, one ought to seek to resolve that issue either by taking an application under Section 84(2) to get a declaration as to the applicability or otherwise, or enforceability or otherwise of the covenants. But if it's accepted that the covenants are binding, then when strong objections arise, I think the developer must, if possible, pause and engage openly with objectors to the extent that you can. And whilst we appreciate there are difficulties with this, particularly in terms of insurance policies, as James mentioned, it's a difficult dilemma to face, but nevertheless, if it is possible, then that engagement should occur. But in any event, do not rush on with the works for fear of being accused of a cynical breach as opposed to just a breach. And I think that's particularly important because the comments that Lord Burroughs made about cynical breaches, I think you can read them, as I've said earlier, as applying to any of the grounds or under Section 84, including the most used limited benefit limb of ground AA. There's a mixed picture there for the developer, but no easy solution to problems where one has challenges by beneficiaries. But I think the idea of open correspondence, explaining one's position and possibly even open offers to the beneficiaries must be at very least considered. Because then you don't get into the position that Millgate got into, which was that it effectively had to accept that it had knowingly breached the restrictions without necessarily being able to give the full picture of what had gone on behind the scenes.
Well, we have another question from the audience, and perhaps I might just ask, please do keep them coming. So how about this one from Natalie Johnston? Are there lessons from this case for non-public interest cases that we can learn?
Well, and that's one of the uncertainties, because when Lord Burroughs talks about being sorely tempted to agree that there's a principle that the cynical developer doesn't get modification, is that the cynical developer relying on the public interest ground or the cynical developer relying on any ground? So could someone who is relying on the limited benefit ground find that it said that they don't fall within the exceptions that Lord Burroughs said are the only reason not to apply that principle? And that is not clear from the judgment.
Yeah, and I mean, against that, we know that cynical breaches or breaches of any kind are only taken account of effectively at the discretionary stage. But in that regard, tantalizingly, the Supreme Court specifically approved what had been said in one of the Upper Tribunal cases relatively recently, the Green Masjid case, that once you'd satisfied the jurisdictional grounds, the discretion to refuse the application should be cautiously exercised. So, you know, it leaves very wide open the question of the extent to which the comments that they make about cynical breach necessarily shut the door on applications on the other limbs of Section 84.
Right. Now, in this case, the houses had already been built, and it would have been a waste for them to lie empty or be torn down, and that's what seemed to feature heavily in the public interest argument. But we have an anonymous attendee who asks, how compelling would an argument in favour of the developer have been if it had couched the public interest in terms of simply a general lack of housing and huge demand for housing specific to the local area?
That's a very interesting question. The answer to that question is that it would not have been compelling. So I think, so far as the current state of the law is concerned, but that's another unexplored issue that comes out of this case, because, as I mentioned, I think when I was talking earlier, the public interest limb has been framed in fairly narrow terms as a result of a 1974 decision. The Court of Appeal very deliberately said, in fact wrongly, that the Upper Tribunal had not followed that decision and had ignored it. But what in fact the Upper Tribunal had said of that decision was it may need reconsideration in future as to its limitations, but had applied the strict test and yet reached the conclusion that it did. What the Supreme Court's decision leaves open is whether there is a possibility of widening the public interest limb to cater for the sort of issues that the questioner asks, which is, you know, could you simply rely on the desperate need for housing as a reason why the public interest limb is engaged? And what the Upper Tribunal's decision suggests is, well, that's a point that may need reconsideration, but it wasn't reconsidered in this case.
And in fact, there are a couple of other tribunal decisions in the 1970s in which that specific argument was rejected on the basis that the particular development wouldn't make a material contribution to housing need. So that suggests, on the status of the authorities as they are, it's a pretty high hurdle to rely on a general argument about the need for housing.
Okay, another question from this time from Jamie Cooper. When you are seeking to ascertain the relevant beneficiaries, would you have to engage with each and every beneficiary to be able to demonstrate to the court that you've acted properly?
Well, that's a great question, and that's one of the sort of problems that the Court of Appeal's decision obviously brought up. Not wholly sort of answered by what the Supreme Court say, but I mean, you know, practically speaking, we know it's impossible to do so. There are often hundreds of potential beneficiaries, and the idea of engaging with all is extremely difficult and perhaps simply not possible. So, I mean, I think it's a case of making some sort of reasonable efforts to do so. To engage with perhaps those who are most significantly affected by the development and who clearly have the benefit of the covenant. But again, these are points that that are, you know, one can't give an easy answer to. One just has to, I think, as a developer, bear in mind, I've got to justify my action at some stage under the discretionary threshold, as it were. I've got to be able to get over that threshold. and to be able to justify, to be in a position where you can justify your behaviour in terms of the way you've tried to engage must be the thing to take into account.
A question from Paul Greatholder, and it may be that you can't answer this one on the basis of continuing to act in the matter, but can you give us any sort of insight as to what the plan is to do with the houses now, or do you have to be tight-lipped about that?
That may be an issue for intersolicitors correspondence.
Right, it may be then enough said. All right. We've had another question about the insurance policy implications in broad terms from Nicola Sutton. Can you just run through the insurance policy implications again? I know you've touched on it, but I think it might be quite helpful if you can, just to outline how that might fit in and or how it fit in this case.
Yes, I mean, as far as the implications are concerned for insurance policies, I mean, obviously you've got to check your policy. I mean, not all policies prevent you from approaching the beneficiaries before, to alert them, as it were, to the covenant. Many will, but not all do. I mean, I think you just have to liaise with your insurance client, as it were, to make clear that the chances of getting modification are going to be improved if particular beneficiaries are approached, and possibly if open offers are made. But without prejudice to your contentions, you can make clear that the covenant's not binding, or that that you're going to get modification quite obviously. So I think that idea of engagement, both with the insurer and also with the beneficiaries, is one that's got to be carefully considered.
Okay, a question from Tim Rayner on the timing of the cynical breach analysis. Did the Supreme Court suggest that the application to modify should have been made not just before building started, but even before a planning application was made?
No, I mean, I think it's before you breach the covenant, and normally a covenant will not prevent a planning application being made. It's when you put the spade in the ground, usually, that you start to breach the covenant, and it's at that point that it's before that point that you should there should be engagement. I mean, what often happens, obviously, is that you're once you make the planning application, very often the beneficiaries will wrongly write to the local authority saying, we've got the benefit of a covenant, this planning permission should be refused. And you often get to know who the likely difficult beneficiaries are from making the planning application.
Right, maybe time just for one or two more. Marcos Tofanello asks, do you have a feel for how hard a developer will have to be seen to minimise or avoid a breach of covenant before making a Section 84 application?
James?
And I think it's going to depend on what options there are for the developer to avoid doing it. And it comes back to the question about whether or not you can serve any public interest in a way that doesn't breach the covenant. So the developer will want to have made sure that they've explored all those options if they want to rely on the public interest ground in due course, that they have exhausted the possibility of doing whatever they want to do in a covenant compliant manner. Right. Well, I think we are heading towards the end. There is one question from Camilla Charlson Gallagher, who asks, do you think it's useful to think about the conditional intention to do works found in the S. Francis case recently as similar to this test of cynicism? Well, Ben, I'd never want to suggest that a case that you're in has any importance beyond a very narrow sphere. but subject to that, it's an interesting question. And it certainly shows a similar reluctance on the part of the Supreme Court to endorse conduct which might be regarded as, in some sense, disrespectful of people's property rights or their rights under statute. So it involves maybe that underlying sentiment. But beyond that, I'm not sure off the top of my head how far one could push the analogy. And it perhaps is cynical, in, as I say, in the sense of doing something which is in a sense wrong. But it's a different focus, really. It's the focus on the breach of covenant rather than on avoiding a statutory provision.
Yeah.
Martin, do you have any thoughts on that?
No, I'd agree with James. I mean, I don't think the analogy actually runs too far. I mean, you know, in our case, not so much in France's perhaps, but in our case, the idea that the Supreme Court was going to be unimpressed by what it termed as a cynical breach, whether it was or not, you know, is not surprising. It's not surprising that the Supreme Court were not going to give any quarter to the idea that your position might be improved in modification applications by knowingly breaching your covenant.
Yeah, absolutely. Well, having been in France this year, I can see the broad connection in that the Supreme Court does not typically does not want to allow rights that innocent parties have to be trodden over by cynical actions, whether in the case of Francis that's acts deliberately designed to get a tenant out where they have no commercial purpose, or in the present case, whether it's a cynical attempt to steal a march on the innocent party. But very interesting question nonetheless. But I think we are just about coming up to our time. We've just had one more come in from an anonymous attendee, which you might just squeeze in, which is this. If the houses couldn't have been built outside the encumbered land, would the result have been different?
Very, very possibly. And there would still have been the hurdle to get over to show that building those houses there was required in the public interest. But the way in which the Supreme Court decided the case would not have been available to them in those circumstances.
Well, thank you. What we might just do now is, just before we wrap up, is we've prepared a poll, and hopefully within seconds, the poll is going to pop up. In fact, there it is. The question is, who's feeling more confident about advising developer clients that they'll succeed under the public interest ground? Please use the voting buttons. Let us know. Me, not sure. And we'd be fascinated to see the results, which hopefully will be available in a minute or two. Well, whilst we wait for those poll questions to come in, answers to come in, let me just conclude by saying to Martin and to James, thank you very much for that really helpful run through the case. And thank you to everyone who's attended as well. I see that we had well over 200 people with us, which is terrific. And a special thanks goes to those who asked questions. And thank you for that, for really encouraging a lively discussion about all the implications of the case. This webinar has been recorded and it will be available on our very own YouTube channel, aren't we woke? Yeah, or our LinkedIn page. And on those channels and pages, there's also recordings of our other recent Wilberforce web chats and webinars, which are well worth checking out if you haven't already. So let me just end with the poll results we have in. Who's feeling more confident about advising developers that they are likely to succeed under the public interest then? Well, it's pretty much an even split. Me is 32%, not me, 39%, not sure, 29%. Well, thank you very much for clarifying that for everybody, James and and Martin, it's clear that there's obviously going to be lots to play for in future cases of this sort. But meanwhile, thank you very much again for joining us, and we'll look forward to the next one. Goodbye.